Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. This episode of our continuing series on the Idaho versus Kohberger case is intended to provide you with an update as to what exactly is going on with the unsealing of this enormously high-profile criminal case out of Latah County, Idaho, where on November 13th, 2022, 4 students of the University of Idaho in a rented home were reported to have been found unalive just steps away from the campus where the 4 were pursuing their degrees. There was very little information that law enforcement, led by the Moscow Police Department, released to the public in the several weeks leading up to the arrest of Brian C. Kohberger, which occurred on December 30th, 2022 across the country at his family's home in the Commonwealth of Pennsylvania. By way of example, when the Moscow Police Department put out a be on the lookout, a BOLO, that many law enforcement officials will do when seeking other law enforcement agencies or the general public's help in locating, for example, a getaway car, or in this case, a car that was wanted in connection with the unalivings, law enforcement will publish a photo of the actual vehicle. Moscow Police Department refused to even do that, although the public learned thereafter that they had quite a bit of video footage of what they called Suspect Vehicle 1. What they did in the BOLO was release 2 photographs of stand-ins, other cars, one of which had a sunroof, rather than releasing a photo of the actual Suspect Vehicle 1. Once Mr. Kohberger was arrested, the defense drafted a non-dissemination, aka gag order, approached the state and convinced the state to go to the first judge in the case, Judge Megan E. Marshall, day 4 of the proceedings, and enter that non-dissemination order. That's why the public didn't see the sorts of press conferences once in a while from law enforcement or the prosecutor or even the defense providing an update as to how things were going on in the case. That gag order prevented that from happening, and it was updated a couple of times throughout the more than 2.5 years that this case proceeded before it was finally rescinded after Mr. Kohberger entered his plea of guilty, as he did in July of 2025. On top of the gag order, there were multiple hearings that were held behind closed doors, not in the public domain, for the public to be able to understand what was going on in the case, which was made even more complicated by what I've called the Mount Everest of documents that were under seal during the entire pendency of the case, including, most critically, the evidence that the Moscow Police Department and the state of Idaho felt would prove guilt beyond a reasonable doubt evidentiary standard. That is the burden of proof that the government has when seeking to take someone's liberty, or in this case, because it was a capital case, life. Judge Hippler, at a hearing in July where the media coalition convinced the court to finally lift that gag order, denied another motion filed by the media coalition asking for this case to be unsealed now that Mr. Kohberger pled guilty. That motion was denied. Judge Hippler announced at that time, at that hearing in July, that there would be a process where the court would be looking at documents starting from the end of the case, which was July of 2025, and then working backwards to the beginning of the case. And what he did is he began submitting orders to both sides, the state and the defense, both of whom were responsible for the motions to seal so many things in the case, and asked them to provide their objections or non-objections to documents being unsealed to the public. He put out 3 orders, one for the months of June and July, and there was a trickle of documents that were released to the public. some unsealed, some with redactions. It was a second order that came out for the months of April and May, and ditto. There were documents that were unsealed, some with redactions from those 2 months. A problem seemed to have occurred. There was a stoppage that happened when it came to the third order, which really then started to look at evidence under seal, because this was the month of January and February and March, when the in limine briefings, the motions, responses, and replies in limine, asking the court in many instances about whether certain evidence should come into the trial or should not come into the trial, which was scheduled to occur back in August of 2025. What type of evidence? Some of the topics of these in limine briefings was CSLI, one of the most hotly contested items in the entire case. Another had to do with IgG DNA, very hotly contested in the case. Releasing the actual text messages that were sent inside of the house on November 13th, 2022, to the outside and other texts coming into the house. They've been discussed, they've been described, but the actual text has never been released. There was another in limine motion dealing with witness identification via bushy eyebrows and so many more things. Judge Hippler went through the same process back in October. He submitted court orders to both sides, the state and the defense, asking for their objections or non-objections. Both sides responded. And then on December 18th, 2025, over 2 months ago, the court entered an order directing the unsealing of dozens upon dozens of documents from January, February, and March to be released to the public, some with redactions, others with no redactions at all. A few items were released on the 30th of December from the end of March 2025, none dealing with the in limine briefings because they were earlier than the end of March. They were quickly brought down off the docket. The last two items that appear on the court docket deal with the sealing of documents. If you look at the court docket, you'll see January 5th, 2026, order sealing states supplemental. This is an additional motion to reconsider unsealing of certain records. And the only item that's up for debate right now is that third court order issued in October dealing with the January through March first quarter 2025 documents. There is yet to be a fourth court order going into 2024 as of this date. The second item from January is the January 29th, 2026 order sealing states supplemental response to court's third order. That's the October 2025 order, ladies and gentlemen, dealing with the first quarter of 2025 documents, Ray sealed documents. The case summary page has not been updated since the 29th of January. And if you go on to the Ada County website, there's a general notice there saying that documents will be released once approved. It continues to be quite perplexing as to what is going on with this case and why was it sealed from the public to the large extent that this case was. The truth of the matter, and it is a sad truth, is that unalivings happen regularly in the United States, and sometimes they're mass unalivings. And those cases are not sealed to the extent that this one was during the 2.5 years that it was prosecuted. The rhetorical question that needs to be asked is why. There is no hint of any other alternative perpetrator, accessory before the fact, accessory after the fact, co-conspirator from the state. And so if the only person that the state says committed these crimes has been behind bars for nearly 8 months, why is this case still largely unsealed to the public? We're going to continue to monitor the docket in the hopes that perhaps this week, as the calendar says, we're approaching the end of February 2026. These documents Judge Hippler ordered to be unsealed back on December 18th will pop up on the court docket, and the next order dealing with the unsealing of documents from 2024 will also pop up on the court docket. Until next time, this is Kathy. Thank you for joining us here today.